Good morning to Miss. My name is Vishwina Sharma. Today I would like to present about criminal court, prosecutor, defendant and defense. I would like to explain about definitions. My first point is definition of criminal court. Criminal court is a court that has a jurisdiction and they also can punish them against the criminal law. Next, definition of prosecutor. This prosecutor is the government who charges the case against individual of criminal. Third is definition of defendant. Defendant is a person that against a type of criminal relief is being seen in a civil cases. Last but not least, definition of defense. A defense is a attempt to avoid criminal or civil blame. That's all from me. Thank you, Miss.
Good morning, Ms. Nandini and my dear beloved friend. My name is Joanna Preeti Narayanasamy. My ID number is 04200117. Today I would like to present about goals and objectives. After learning the chapter, we will be able to summarize the development of American court, including dual court system. Besides that, we will also be able to describe the typical state court as well as some of the differences between state courts and federal court system. Furthermore, we will also able to describe the structure of federal courts along with the variation type of federal courts. Finally, we will also able to describe the pre-trial steps and activities. That's all from me. Thank you.
Good morning, Miss. Now I like to present on about the elements. So the elements in criminal court is alternate tables, bailiff station, court clerk station, court reporter stations, jury's box, judge's bench, spectator seating, and lastly the witness stand. And for prosecutor, the elements are the defendant committed the crime and disprove the defense. Furthermore, the elements of a defendant is selecting and returning counsel, planning a defense strategy with their alternate, deciding what information to provide to the defense team, and deciding whatever plea to enter, and deciding whether to testify personally and determine whether to file an appeal if convicted. Finally, the elements of a defense is a use of force. Use of force is a likely self-defense, defense of property, and defense of other. Secondly, explanations of the statute limitations and the defense of choice, and last but not least the victim choice. Thank you.
Hi Miss, my name is Marita. I am Diploma Enforcement Management student batch 21. ID note DEM 0520040. Today I would like to talk about the importance of criminal court, prosecutor, defendant and defense. First of all, I would like to talk about the prosecutor. The trial court of general jurisdiction operates within a fact-finding framework called the adversarial process. That process pits the interests of the state represented by prosecutor against the professional skills and abilities of attorneys. The adversarial process is not a free-for-all, rather it is constrained by procedural rules specified in law and sustained through tradition. The prosecutor, also called solicitor, district attorney, state's attorney, country or commonwealth attorney. The prosecutor attorney also the primary representative of the people. The prosecutor is an attorney responsible for presenting the state cases against that defendant. An attorney whose official duty is to conduct criminal proceedings on behalf of the state or the people against those accused of having committed criminal offences. Prosecutorial discretion. The decision-making power of prosecutor based on the wide range of choices available to them, handling of criminal defendants, the scheduling of cases for trial, the acceptance of neglected pleas, and so on. The most important from our prosecutorial discretion lies in the power to charge or not to charge a person with an offences. Exculpatory evidence. Any information having a tendency to clear a person of guilt or blame. Until relatively recently, prosecutors generally enjoy much of the same kind of immunity against liability in the exercise of their official duties that judges do. Secondly, defendants that are accused criminal law violator whose interests at trial are represented by defense counsel and ensured by the judge. Although defendants may often choose to represent themselves, few actually to do so. For example, self-representation, defendants exercise choice in selecting and retaining counsel, planning a defense strategy with their attorney, deciding what information to provide to the defense team, deciding what plea to enter, deciding whether to testify personally, and determining whether to file an appeal if convicted. Lastly, defense. An attorney trained in the practice of criminal law whose task it is to represent the accused at trial, to present evidence in the defendant's favor, to cross-examine prosecution witness, and to ensure that the defendant's civil rights are not violated. A licensed trial lawyer hired or appointed to conduct the legal defense of a person accused of crime and to represent him or her before a court of law. Thank you.
My name is Nisha, daughter of G. Simulku, and I'm 19 years old. Today I'm going to present about example cases in criminal courts. In 1992, the case of Kenny v. the Mayuris, the US Supreme Court ruled that a respondent is entitled to a federal evidentiary hearing if he can show cause for his failure to develop the facts in the state court proceedings. Second is in 1993, the case of Herrera v. Collins ruled that a new evidence of innocence is no reason for a federal court to or a new state trial if constitutional grounds are lacking. 43 US Supreme Court case of MC Knapp v. US, 48 hours following arrest became a standard maximum time by which a first appearance should be held. In 2012, Thomas Lubanga, a rebel leader in Eastern Congo, is guilty conscripting child soldiers. Last but not least, it's the US Supreme Court case of US v. Hazard in 1984, decided only a few months after enactment of federal bail reform, held that Congress was justified in providing for denial. Thank you.
Hi Miss, I'm Janita Angelin, daughter of Munasami. I'm from DEM and my ID number is DEM 06200055. Today I'm going to talk about some reference about subtopic from the page of 217 from the reference book. So, prosecutors they may serve a quasi-legal advisor to local police, and prosecutors to have the burden of proving guilt. State prosecutors are elected and generally serve 4-year terms with the possibilities of continued re-election, while the defendant must be represented at their trial. An appeal by a condemned defendant asks that a higher court review the action of a lower court hearing to ensure that those proceedings were carried out in a fair manner and in accordance with proper procedure and in a state law. State statutes generally require the sentences of life imprisonment or death be automatically reviewed by the state Supreme Court. Occasionally, however, an appellate court will determine that the trial court erred in allowing certain kinds of evidence to be heard, that it failed to interpret properly the significance of a relevant statute, or that some impropriate occur. When that happens, the verdict of the trial court will be released and the case may be sent back for a new trial or remand. When a conviction is overturned by an appellate court because of constitutional issues, or when a statute is determined to be invalid, the state usually has recourse to the state Supreme Court when an issue of federal law is involved, as when a state court has ruled a federal law unconstitutional, it goes to the US defendants. They are who are not satisfied with the resolution of their case with the state court system may attempt an appeal. For such an appeal to have any chance of being heard, it must be based on claim violation of the defendant's right as guaranteed under federal law. They rule that a respondent is entitled to a federal evidentiary hearing only if he can show cause for his failure to develop the facts in the state court proceedings and actual prejudice resulting from that failure, or if he shows that a fundamental miscarriage of justice would result from failure to hold such a hearing. Justice Brian White, writing for the court, say it is hardly a good use of scarce judicial resources to duplicate fact finding in federal court merely because a petitioner has negligently failed to take advantage of opportunity in state court proceedings. And that's all from me, and thank you, Miss, for hearing me.
Good morning to Miss Nandini. My name is Jariraj Thomas. I am DEM Batch 21 student. My ID number is 06200037. This is a criminal justice group assignment video presentation. My question is number 7 summary. In the United States, there are two judicial systems. One consists of state and local courts established under the authority of state and local governments. The other is the federal court system created by Congress under the authority of the US Constitution. This dual court system historically results from general agreement among the nation's founders about the need for individual states to retain significant legislative authority and judicial autonomy separate from federal court. In most states, criminal courts can be classified within a three-tiered structure of two trial court, excellence, and appellate level. There are many differences among the state court systems. However, so-called reform states are characterized by relatively streamlined judicial systems consisting of trial courts of limited and general jurisdiction, supplemented by one or two appellate court levels.
Good morning. Let's start our presentation session for today. My topic is about conclusion, criminal courts, prosecutor, defendant and defense. So there are generally two types of trials, criminal and civil. The hierarchy of courts begins from the magistrate court, session court, high court, court of appeal and finally the federal court. The jurisdiction of the courts in civil or criminal matters are contained in the Subordinate Courts Act 1948 and the Courts of Judicature Act 1964. Article 121 of the Constitution provides for two high courts of coordinate jurisdiction, the High Court in Malaya and the High Court in Sabah and Sarawak. Next, the prosecution is the legal party responsible for presenting the case in a criminal trial against an individual accused of breaking the law. Furthermore, the prosecutor represents the government in the case brought against the accused person. For example, a lawyer who takes legal action against someone accused of murder is an example of a prosecutor. Finally, in civil proceedings and criminal prosecutions, under the common law, a defendant may raise a defense in an attempt to avoid criminal or civil liability. Apart from that, other parts of defense include the opening and closing arguments and the cross-examination during the prosecution phase. Let's wrap up our presentation session. Thank you very much.